There is something to be said for consistency.
That's right. Steve Gosney representing Anne Marie Farley, case number 5D 11-1206. And there's actually quite a number of points, and I think this is one of those cases when things go wrong, they go way wrong. And there's a lot of errors in this particular trial and whole situation. But I'd really kind of group them in. One, I appreciate counsel for conceding the 1 point on the PD fee. But then there's sort of these other two groupings, and one is the valuation issue, which I think was adequately briefed, and I'd really, rather focus on the other issue, and that is the sole basis, should the JOB have been granted, the sole basis, and it's kind of point one and point two, for the conviction here was this video. And the video was placed in evidence. And then that was compounded. Based on that, you have then this testimony of this witness, who's the accuser, who came in and viewed the video and says, oh, the video shows this person stole my cell phone. Now, the key fact that has to be understood here is that she left the store and says, I lost my cell phone. And she comes back to the store. She does not know that cell phone is stolen. So the only way that she can accuse my client of stealing it is through the videotape.
Well, there's also her testimony. I mean, say I have a cell phone here, and the only other person up here is Judge Orfinger. And I put the cell phone down here, and I leave for 5 minutes and come back. And there's a video that shows that the only other person within reach of that item was Judge Orfinger, and it shows him taking something, can't see what it is, but reaching and taking something and putting it in his pocket. Why wouldn't that be sufficient if I come back and that's no longer there?
Well,
I mean, if you combine the testimony with the video, I agree with the video alone, it's insufficient. But why, when you combine the testimony with the video, don't you have enough?
Well, and because the fact is that's not what this evidence is. This is a public place. There's lots of people. It only shows this one little snippet of the incident, which there's multiple people going through. It never shows my client taking anything. It
does show your client picking up something.
Okay,
and putting it in her purse.
Well, she has an object in her hand, which when she approaches the counter, she has in her hand. When she walks up to the counter, she has an object in her hand. Now, if you stop motion that, you can see as she's backing, when she puts the beer up on the counter, backs away, there's an object in her hand. Well, if you stop motion that, say, see, she has that object in her hand.
But then she picks up something. I mean, there is an object that she picks up. You can't see what it is, but there is an object she picks up.
Well, the accusation, the allowing of this witness who did not see my client do anything to go on to a running commentary and basically violates the best evidence rule, and as I argued in point two.
Let me just ask, while we're talking about that, I went back and I watched the video. I didn't stop motion it, and maybe I need to do that. I just kind of watched it a couple of times, the relevant part. Is there a problem with the alleged victim here coming in and just sort of saying, well, okay, here, what you see here in the video, that's me, and I'm standing at the cash register, and then that's me walking out. That doesn't seem to be a big deal. What concerns you is when she comes in and gives the narration when she's not in the store and says, now you can see this is the lady that was standing next to me, the defendant, and you see her walk up, and that's, again, she was there for that. You walk up and she's got the beer in her hand. And then when she leaves the store, the alleged victim, she apparently then testifies, now you see on the tape, that's when she picks up my phone and puts it in the purse. That's really the part that you're focusing on.
Exactly.
And I guess the question, though, is even if that's error, isn't it? I mean, to me, I agree. The best evidence is whatever's on the tape. I mean, are we to assume that the jury was so swayed by her testimony versus what they could see for themselves?
Well, and it's kind of a novel question. It's like, well, how can the jury have made this mistake? How can they have convicted her of grand theft when the video doesn't show, as conceded, it doesn't show that she stole anything? except for the addition of her testimony. Well, and the reason is because of the addition of her being able to stop motion that video and stop and say, look, right in her hand, there's my cell phone, and then reverse it, which confuses. It's not a good video, and the jury says, well, she sees it, and she's got it in her hand.
Would it be proper for the alleged victim here to say where her hand goes on the counter, that is the location where I had left my phone?
Well,
I mean, acknowledging that she shouldn't have said, that's my phone she picked up, but could she have said where her hand went is the location on the counter where I had put my phone down?
right. Well, it's making it a little trickier. It's a closer question. I'm not sure. What I'm saying here is that
He's a very tricky guy.
no, well, I'm not sure, but I mean that's a closer call. Here, I mean, she's saying, look, that person right there, that person sitting in that defendant's den, she's taken my cell phone and putting it in her purse. Without that, it's not clear at all from the video. And she did not witness that. That person did not witness that. She came back to the store thinking she lost the phone, and she's basing that on her judgment call of what the video shows. And she's allowed to stand in court and back motion and narrate this whole video, which then creates this impression, well, we don't know what the video says, but she seems convincing, and she's the better looking witness, so let's go with her. And that kind of those two errors combine to create a conviction here that really to the detriment of my client. And I think that the best evidence rules violation led directly to the conviction because the video alone does not show theft. It should have been JOA'd at that. Now, because of the testimony, and the court did rule, says, well, we had some testimony from this accuser, but allowing the testimony to that core element was what was error. And therefore, it should have been granted but it was not granted because the testimony was in there, but it shouldn't have been in there. So it's sort of 1 and 2 are kind of a self-reinforcing point that end up in a conviction, a wrongful conviction. So that's the point I want to focus on. I've got lots of time, so I'll reserve that if you don't have questions on those.
Thank you.
Thank you.
May it please the court, counsel. I'm Megan Salant from the Attorney General's office. I'd first like to point out that the victim testified to almost exactly what Judge Evander said. The victim said on page 26 of the transcript, she says, where my phone was, it appeared to go from this woman's hand up to her purse. So she, in fact, did say that is where I set my phone down. Now you can see the defendant's hand, and now you can see the defendant's hand with my phone go into her purse. So exactly your example. If she had said that, that's exactly what she said.
So would you agree it's improper to say with my phone?
Well, I'm just pointing out that she said that is the location where my phone was, that is where the defendant's hand appears to be, and now it appears that her hand is going into her purse.
Well, but the problem is, it was okay for her to say, this is where I put my phone down.
Which she did, correct.
It's the rest of it, though, when she gives, sort of the running commentary. Now watch your hand, go down where I put my phone down, pick something up, and put it into the purse.
Right.
I mean, I watched the tape about 3 times, and I mean, I haven't gone back and stopped it and looked at it. I don't know. Have you seen the tape?
Yes, I have. I've seen it a number of times, and I've watched it at multiple speeds.
I can't tell much from it.
Would be a fair assessment to say that it indicates she picked something up, but that you can't tell what it is.
Correct. And the thing that she picks up is in the location where the victim indicates she set her phone down.
Well, here's what she says, right, looks like there's the phone, looked at right there, and she's apparently pointing. And right about now, this black object goes there, and she steps away, I'm busy doing this. So she basically says, looks like there's the phone, looked at right there. So she's identifying the black object as the phone.
Correct.
If you did not have this testimony from this victim, what other evidence would you have that the defendant was the one that took the telephone?
I mean, I think that...
This is basically it, isn't it?
Yes. This is the evidence that the state presented. They presented the videotape and the
testimony. So if you did not have her statement that, right, looks like there's the phone, looked at right there, and her testimony pointing to it and basically saying that this is the telephone that she took, then obviously the court would have had to direct a verdict, right?
Well,
So
if
your
the-
whole case hinges on this testimony.
Well, but even if the victim hadn't been allowed to narrate during the video, the victim still would have been able to testify. So let's say that the state had been to be able to show the video on its own, and then the victim had been able to testify to what she knew, which she obviously would have been able to do. She could have said, I put it in front of, it's a little bit unclear, again, because we weren't
Well,
watching
it sounds like even the victim didn't really know whether that was the phone or not. It says, looks like there's the phone looked at right there.
Correct.
And then she says where my phone was, it appeared to go from this woman's hand into her purse. So even the victim didn't really know whether in fact that was the phone or not. She said it looked like it, and that's where I last left it, and that was it, right?
Right, except that going back to the example that was given earlier, the victim knew exactly where she set down her
Do you
phone.
think that's enough to convict somebody of a criminal?
Well, I think that if the jury is going to assume, or on a motion for judgment acquittal, if we're going to assume all the facts in the light of the most favorable to the state, then I think that yes, if the jury watches the video and they hear the victim, and they can watch the video, they're watching the video at the same time.
Well, it seems to me like the victim is basically testifying as to speculation. Looks like that's the phone, and
But
you know the victim goes in and basically testifies.
Right.
Based on a certain degree of speculation that that's what happened.
But if the victim...
And so the jury is just supposed to take that and weigh it, and that's...
Well, no, the jury has the opportunity to watch the video themselves. And if the victim had testified that...
What do you see from the video that shows that it's the telephone and that it was the one that was stolen?
Well, what I see
The video doesn't show that, does it? I mean, it shows a black object, and that's about it.
Right. And the quality of the video is poor enough that you can't see, but the victim testifies that that is where she set down her phone. And that is where, and then you can see without the victim's testimony that is where the defendant's hand goes, and that the defendant's hand goes there. It appears to me the defendant's hand goes there without anything in her hand. And then the hand goes there, and then the hand comes away with something. And then the hand goes into her purse. But even if the victim had testified that she was wearing a yellow shirt, which she clearly wasn't in the video, and so she says, look at me, there I am in a yellow shirt, and the jury's looking at the video saying that she's not wearing a yellow shirt. What is she talking about? The jury it's their prerogative to look at that and say, she's full of it. She's not wearing a yellow shirt. We're not going to believe her because that's clearly not backed up by what the video shows. So the jury is in a position to judge the weight and the credibility of what they see. And that's why the JOA was denied, because when you take the evidence in the light most favorable to the state, the jury can look at that and believe that. Just like you said, we're not sure what it is, but the jury was able to see it with the victim's testimony and make a determination on their own as to what and who they believed.
Let me ask you about the valuation.
Sure.
If you include the case, I guess the purchase price was $324 1 month ago.
Correct.
And there was testimony that the phone still works.
Correct.
Did you need some kind of testimony that it was in as good a condition as when I bought it? Was that testimony?
Certainly that would have made it a stronger case for the state, but I think that I do believe that the evidence was strong enough to support the depreciation value of that in a month is going to be very minimal.
Is that something we count on the jury to know? I mean, what, if it was 6 months or a year, would we as an appellate court say that the state's evidence was insufficient, but a month it was sufficient?
Well, there's, excuse me just a second. In one of the cases, like for instance in the KW case, the court stated that it was clear that the value was over $300, that it was obvious, and they allowed the jury to make that conclusion from the evidence that was presented.
Is it obvious here with an item for $324 a month old?
I would argue yes, that the value of an iPhone is well known. It is well known that it's over $300. Because even if she had paid $299 for it, you have to,
we don't know if she had a contract with it.
Right, you're absolutely right. But I do think that there is enough common knowledge to know that the depreciation value of something like that over a month is going to be very minor. But you're absolutely right that was not presented as evidence.
So a month would be okay, but when do we get to the point 2 months, 6 months?
I mean, I could argue that you get to the point when something new comes out. I mean, an iPhone is as valuable as it is the day you bought it until there is something better. I mean, the prices on those phones, and again, this is just knowledge. This wasn't in evidence, but the prices on those phones, it stays static. Doesn't change.
And we know that how?
I'm just, like I said, that's just personal knowledge. That you're right that was not in the evidence. But I do think the fact that
I've got an iPhone back there that's 3 years old, but it works well. I'll sell it to you for $299.
But I can guarantee you that the iPhone that I have that works well, that I just purchased, probably makes yours worth less. That's all. That's what I'm saying, is that once the technology changes, obviously the value becomes less. Anyway, I think that the main point that the state would like to make is that a JOA argument has to do with the sufficiency of the evidence, but what we're really dealing with here is the weight and the credibility of what the jury gave.
Well, but here's, I guess, the problem. Let's assume that the evidence that we had was the victim saying, I went to the store, I put the phone down here, and when I came back to get it, it was gone. And then the state plays the videotape. And so we see, so we don't have the commentary from the victim. She just says, look, this is where I put the phone down. And we leave it to the jury to look at the tape and decide whether or not the defendant's hand goes to that general area.
Right.
Whether or not it picks up an item, whether that item is the cell phone, and whether it goes into her purse. We leave that to the jury to glean.
Right.
If that's the testimony that we had, would that be sufficient to pass a JOA?
Yes.
Okay. But here we've got more. We've got the running commentary. So I guess the question is, you would agree with me that if we had the evidence I just described, it's still, given the quality of the videotape, far from the strongest case in the world.
I would agree with you.
This is one of those where, if I'm the trial judge, I'm sitting here thinking, this is a really close call.
Right.
But now we've got a little bit more. We've got what I think you concede is largely improper running commentary from the woman that says, now watch the defendant's hand. She reaches down to where my phone was. She picks up something that appears, it looks like my phone, and puts it in her purse. The question then becomes, if we agree that evidence is improper, don't we have to say in the context that it was harmless error, and in a case like this that is admittedly pretty darn weak, it doesn't seem to me much to constitute harmful error.
Well,
because I look at it more, I agree with you. I think it's probably passes a JOA if all you've got is her saying, I put the phone down, they play the tape, and the jury,
right,
does what it does. I'm concerned when a case like this that is, so close, so weak, and then you add some additional testimony that I think is clearly improper. It's not like super inflammatory, but it's clearly improper in a case that's right on the line anyway. For me to say that that's harmless error.
I think that, I think that it's harmless. I do. I think that...
Well, you know what the value of cell phones is, so you should know what harmless error is.
But you said just a few minutes ago that you had no other evidence, and your case rested solely on what was seen in the video and the commentary by the victim, and that's it. That's all you had.
Right. Except that the problem.
You've got nothing else in this case.
Right. Except that the problem, I think, going back to what Judge Orfinger said, is that they could have been done separately, and there wouldn't be an issue, right? The victim could have said, I set my phone down on the counter in front of, and again, I don't understand what she was saying, but I believe there was a black register, and I think that's where she's saying she put it down. So she could have gotten up in the stand and said, I set my phone down in front of a black register, and I moved down the line, and then I came back and it was gone. And then they could have played the video, and you would have seen the victim standing in front of that black box or register or whatever that is, her move on, and then you would have seen the defendant come up.
And you say that alone would have been sufficient evidence to convict this person of this crime beyond a reasonable doubt? I mean,
If that's what the jury saw, and that's what the jury
what happened
believed.
is the added commentary by the victim is, and I don't think that it was proper for the victim to speculate as to, well, this appears to be the phone, and this appears to be this, and it appears that she put it in her. I mean, that's all speculation too.
Right.
And
But she also
and that's it. That's what made your case for you, was that improper testimony, right?
well, again, I don't think
You have
that,
nothing else. What else do you have?
But both of those things, whether or not we have or don't have both of those things, they still could have been admitted as evidence separately. So it's just what the defense's objection to
I'm
is
not
just
so,
the
I'm
timing
not so
of it.
convinced that just the testimony, well, I left my phone in this area, and then, the video shows that she picked something up from that area. I'm not as convinced as Judge Orfinger that would have gotten by a directed verdict. I don't know whether I wouldn't have granted a motion for directed verdict based on that alone. And then we have the victim's testimony that's basically, as far as I can see, speculation too.
But she
And
doesn't use...
I quoted you what she said and what her testimony was. It appears, it looks like.
Well, but she also didn't say, absolutely, that is what the defendant is doing right there. So the jury hears her. The jury knows that what she's doing is speculating. So the jury is left to their own to decide whether or not they believe her. And I would like to point out that during deliberations, the jury did ask to see the video themselves, and they were able to. And so they were able to watch the video without any commentary from anybody and make a decision about whether or not that's what they saw.
I would think that they would be watching the video with the commentary in mind, replaying in their mind what the victim said. The victim said this and pointed to this and had the pointer and said this was the telephone and all of that. I mean, it just seems to me like your case hinged on that testimony, and the question is whether it was appropriate to allow the victim to testify. If it was, then that's fine. If it wasn't, well, we'll just have to see.
Well, and our stand is that the jury was there to view the video, to hear the witnesses, and to make their own credibility and determine the weight of the evidence that was presented to them.
Thank you so much.
Thank you. I ask that you affirm. Thank you.
Well, that went so well, I don't know if I should come back.
Well, let me ask you this. If the witness had stopped it, that is where I put my phone down. The place where the defendant's hand goes to on the counter. If she stops there, could the prosecutor on closing have, in essence, said everything the victim said as far as, well, you see her pick something up, rely on your own recollection of the video, but you can see her pick something up, and that's the location that the victim said she put her phone down, and you can see there's something in her hand, and you can see it go into her purse. Could the prosecutor have said exactly those things that the victim said in closing?
Well,
And suggest to the jury that was the phone?
Well, are you asking whether it would be proper for the accuser here to testify as to her own actions and where she placed the phone? I say yes. She could testify to that.
Right. And having done that, could the prosecutor on closing show the video, while showing the video, say, look, there's the defendant's hand, it goes right to where, and it's empty, and it goes right to the counter where the victim says she left the phone. Now look, she's picking up her hand, there's something in it. Now look, it's going in the purse. Could the prosecutor have in essence said what the witness said?
Well, they wouldn't have had that opportunity.
It wouldn't have been sworn testimony, but...
Right, they wouldn't have had that opportunity because the JOA would have been granted because the video doesn't show that.
I'm just asking as far as error.
Right, well,
I mean, if it could have survived the JOA, I'm getting to the issue of whether it's harmless error or harmful error, if it would have survived the JOA, would the prosecutor be able to say exactly what the witness said that witness shouldn't have been allowed to say?
Was that last bit there? The testimony, she can testify as to her own actions and what she did on the video. But when she's testifying in
Right, my question is, let's say the judge stopped the testimony right after she said, that's where I put my phone, where the defendant's hand is going to on the counter. All right, and that's as far as the witness was allowed to testify, okay? And then the jury sees the video and the motion for JOA is denied. Now, in closing argument, could the prosecutor say, look, you see her hand go to that place. You see her hand going empty when it got there, but coming up with something in it and going to her purse, and I submit to you that was the cell phone. Could the prosecutor have made that argument properly?
Well, that's just not the case here, because she has an object in her hand when she approaches the counter. So, in fact, I printed out little
Well, I
excerpts
saw
from
the video,
videos here.
and when her hand goes to the counter, I didn't see an object.
Well, and if you look at 72606.
She had at one time, she had something in her hand, but not when she goes to the counter.
Well, and that's, I think she does have something, and again, this is one of those things. This is why we have such a fine credit. She has, I believe, her keys in her hand. It's hard to see, but in her hand, in 2 frames that you can stop motion, she has an object in her hand. And the reason it's deceptive is because if you stop motion it and show this one, which is where she's backing away at 7:25:58, whoops, this one, that's an object in her hand, and it appears to be a phone.
I looked at the video several times with the stop motion, so...
But when she approaches, and these 2 times, she has the object in her hand already. Now, if you stop and say, aha, there it is right there, she's got an object in her hand, and that's where she testified. I guess a prosecutor can do that, can comment on that, but that's not this case. This case, not only does the video not show that, it wouldn't have survived a JOA, there's also, it just exists that this person speculated as to what happened here. And in fact, she even talks about, she's taking brochures for herself, and she's saying this object here that's in her hand was in her hand when she approached the counter, according to, the video. But at least let's concede that the video does not show or prove beyond a reasonable doubt that my client took anything. So then what do you have? You have this improper testimony, which is basically her opinion of what the video shows. So it goes back to the video. So we're kind of back in this thing. It's the video, and then the improper commentary allowed the case to go forward beyond a JOA. If you have anything else, I'll cut it brief.
Thank you.
Thank you, Your Honor.
Thank you both.